have it.
I beg to move that this House do now adjourn.
Colleagues should be leaving quietly, and Mr. Kit Malthouse, Adam Jogi, walking past the dispatch box. Questions to leave, colleagues to leave quickly and quietly. Much quicker. The question is that this House do now adjourn. Sam Carling on safeguarding in small religious organisations, and I call Sam Carling.
Thank you very much, Madam Deputy Speaker. Over this Labour government's term in office so far, we have spent a lot of time discussing and highlighting the evils of child abuse and the exploitation of children, in particular women and girls. And there's been a lot of progress. The audit from Baroness Casey into grooming gangs raised several recommendations which we've already been putting in motion, with the reforms we're making to taxi licensing and safety through the English Devolution Bill being a key example. But I want to open today by talking about an issue which I have previously discussed with the Minister. That is the mandatory reporting of child sexual abuse, one of the key recommendations from the Independent Inquiry into Child Sexual Abuse, ICSA. I approached this issue as someone who grew up in a small religious organisation, the Jehovah's Witnesses, which ICSA recognised as having a serious problem with child sexual abuse. Last June, I stood here and highlighted my concerns that the government's proposals to introduce mandatory reporting in the Crime and Policing Bill have been significantly watered down from ICSA's recommendations. And I raised three issues. Firstly, a lack of proper sanctions for non-compliance. Secondly, the fact that the duty proposed is limited to applying only when someone receives a direct disclosure or witnesses abuse happening, not when they have strong reasons to suspect it, only when they know. And thirdly, loopholes in who is included. In particular, the drafting required religious leaders to have unsupervised contact with children to come under the duty. And I set out why that would allow most lay religious leaders to escape the duty despite holding enormous power and influence over their followers, using the particular example of the Jehovah's Witnesses. And I do have some good news to begin with. Just a few hours ago, the House of Lords approved a government-backed amendment to remove the word unsupervised from that definition of religious leaders. And I want to thank the Minister, as well as her Lord's counterpart, Lord Hanson, for listening to my lobbying on that front. That small change could make a real difference in protecting children from abuse in small religious organisations. But it will only make the most difference if we fix the other two issues, where there's not been as much progress. I won't rehash my arguments in detail here about why they are so critical. I will give way.
And Speaker, first of all, can I commend the Honourable Gentleman for North West Cambridgeshire for bringing this forward? And he's spoken this before some time ago, and he made a very, very good case, and I support him in the case he's putting forward. And I want to give him an illustration if I can. A 2015 report by the Northern Ireland Assembly revealed that small, unaffiliated groups, including those that use church or faith premises, found gaps in relation to child protection and safeguarding, and that they might not be subject to credential checks. So does the Honourable Gentleman agree, and I believe he does, with me that legislation and guidance must be up to date and strengthened to ensure smaller organisations do not fall through the gaps of ensuring proper safeguarding, therefore increasing protections for all children across the United Kingdom of Great Britain and Northern Ireland? The Honourable Gentleman deserves to be congratulated for what he's doing here tonight. Thank you.
I'm very grateful to the Honourable Gentleman for raising that, and it sounds like some really helpful evidence and a really good example which I'll certainly go away and have a look at. So I won't rehash the arguments now that I made in June, but I will say this. ICSA were clear, having examined the issue in huge depth over many years, that both strong sanctions and the inclusion of reasonable suspicion were essential to create a duty that works. And their views have not changed. On Friday, 2 of the 4 ICSA panel members, Sir Malcolm Evans and Ivor Frank, wrote to the Home Secretary pressing for the duty in the Crime and Policing Bill to be strengthened to comply with their original recommendations.
Will the Honourable Gentleman give way?
I will give way.
I thank my honourable friend for giving way, and I believe that Alexis Jay told that the Home Affairs Committee that actually this mandatory reporting was one of the most important recommendations. So does he agree with me that it's really important that we deliver it in full and that we don't give any leeway where there is reasonable evidence that abuse may be occurring, that people can get away without reporting that suspicion?
I'm really grateful for that contribution from my honourable friend. I absolutely do agree with her. It's really important that we listen to ICSA, who spent many, many years on this, and deliver that which they recommended. In religious organisations, where there is such a strong culture of distrusting secular authorities, there is no other way to make them do the right thing. And I again highlight the work of the Australian Royal Commission, which found that the Jehovah's Witnesses in that country had documented 1,006 cases of child sexual abuse and reported not even one to police. Not one. That is not an accident. That is a systemic cover-up on a catastrophic level. The government's case for not fully complying with ICSA seems to rest on two arguments. Firstly, that strong sanctions for a failure to report child sexual abuse would create a chilling effect that stopped people wanting to go into professions that work with children. And secondly, that widening the duty to include reasonable suspicion would produce a flood of reports that would overwhelm our system. And the government wrote to me to say that their position on these issues is supported by expert stakeholders, including the NSPCC, the Lucy Faithfull Foundation and the Centre of Expertise on Child Sexual Abuse. I will give...
Thank you very much for giving way. And I'm sure the honourable gentleman realises, doesn't he, that I think that it takes an average of 26 years for children to disclose being victims of sexual abuse. And so it's absolutely critically important that the reasonable suspicion of abuse is included, as well as the trigger for a duty to report, and that the whole business of in small, high-demand religious organisations where cultural norms prevent open discussion of sexual harm and discourage mandatory reporting, that needs to be overturned.
To the Honourable Lady, I know she's done a lot of work on this, particularly making sure that the seal of confessional isn't exempted from mandatory reporting, and I very much appreciate her work on that. It's really important. She says, and I'm sure she's got the correct figure, that it takes on average 26 years for someone to report child sexual abuse, having been a victim themselves. And I think that just goes to show that we can't have a duty that just relies on that. We have to make sure that people are empowered and will report their reasonable suspicion too. So I met with all of the stakeholders that I've just cited, and many more, and not all of them do back the government position. The NSPCC are deeply concerned that the professional sanctions proposed by the government as the only consequence for non-compliance aren't enough. They don't want sanctions that could lead to a criminal record, but very much want stronger civil sanctions, including potential fines. And so there is ample space, I would argue, for a well-thought-through compromise here. And I drafted an exemplar amendment for how civil sanctions could work based on the Home Office fine-issuing powers in the Immigration, Asylum and Nationality Act 2006, which Baroness Gray-Thompson tabled in the Lords to debate earlier today. Similarly, the NSPCC feels strongly that the mandatory reporting duty should include reasonable suspicion as a trigger, which raises concerns about why the Home Office had cited them to me about not having that position and using that to therefore bolster the government position. Some of the other stakeholders cited as agreeing with the government have also expressed a much more nuanced position to me, accepting that it is finely balanced and their concerns could potentially be ameliorated through effective training, which I know there's also been amendments on previously. And on these issues, the international evidence is so clear. Many countries with mandatory reporting have criminal sanctions, including a significant majority of US states, France, Australia, Croatia and Canada, and I will give way.
I thank my honourable friend for giving way and congratulate him on securing this debate. On the matter of reasonable suspicion, would he agree with me that within any closed community, but including religious organisations, it is a characteristic of abuse that people do have suspicion and that often nobody feels able to speak up, and that bringing reasonable suspicion within the definition of mandatory reporting, which comes onto the statute book, it is a really important safeguard, particularly in those contexts. It creates an additional duty that could deal with circumstances that are actually pretty common.
I agree completely with my honourable friend, and I think in the debate in the House of Lords earlier today, Baroness Gray-Thompson gave a really good example when she was a younger athlete and observed some of this behaviour from sports coaches, and she believes that having had a duty with reasonable suspicion in it at that time could have really helped to deal with some of that. So in none of the countries I named earlier has the feared chilling effect arisen, despite strong sanctions for failure to report. Nevertheless, as I've set out, firm civil sanctions would be a really fair compromise supported by virtually all stakeholders. And on the concerns about floods of reports, we just again have to look at the international evidence. It doesn't happen. Extensive research by Professor Ben Matthews in Western Australia, which has both criminal sanctions and the inclusion of reasonable suspicion, found that while there was an increase, the number of substantiated investigations, those with the finding of abuse, doubled from an annual mean of 160 in the pre-law period to 327 in the post-law period, indicating twice as many sexually abused children were being identified. Compare that to Wales, where ICSA was told that the introduction of a weaker duty in 2016 had, quote, not led to a substantive change in practice, end quote. And at this point, I also want to highlight that the NSPCC, Centre of Expertise on Child Sexual Abuse and Lucy Faithfull Foundation all want to see the government clearly criminalise the intentional concealment of abuse. At the moment, Clause 79 in the bill criminalises stopping a mandated reporter from carrying out their duty to report. That's very welcome. But I do think it needs to be broader. In the Jehovah's Witnesses and other small religious groups, there is ample evidence that religious leaders regularly stop victims or their parents reporting abuse to police because it will bring reproach on God's name. As parents and victims won't be mandated reporters, that therefore will remain completely legal. So once again, I urge the government to fix these loopholes. The government's own impact assessment indicates that this duty will increase the child sexual abuse offences recorded by police by just 0.3%. So vulnerable children need us to create a much stronger duty to report this abuse as ICSA recommended. By doing so, we can shine much needed light on safeguarding failings in small religious groups and others and protect so many children. I'm now going to move on to discussing other safeguarding issues in small religious groups, beginning with shunning. Again, in the Jehovah's Witnesses, this has long been called disfellowshipping. When someone commits a serious sin in the eyes of the religion, their believing family and friends are ordered to shut them off entirely and treat them as though they are dead. The same applies when someone voluntarily leaves, and the Australian Royal Commission looked at this too, through the lens of the position it places victims of abuse in. They said as follows: the Jehovah's Witness organisation's practice of shunning members who dissociate from the organisation has the very real potential of putting a survivor in the untenable position of having to choose between constant re-traumatisation at having to share a community with their abuser and losing that entire community altogether. It happens all the time. The culture of non-reporting and forgiveness for child abusers leads to them remaining at large, and the victims are silenced, told that their abusers have been forgiven by God. So many leave, and then it is they who lose their entire families. It is victim blaming taken to extremes. And let's consider those removed involuntarily for apparent grave sins. What might constitute those? Well, how about being gay? Religious teachings about homosexuality are regularly equated to paedophilia. They are lumped together. Let me read a brief quote from their Awake magazine, a key publication intended to teach believers, which says as following: "True, some individuals may very well be prone to homosexuality, but a Christian cannot excuse immoral behaviour by saying he was born that way. Child molesters invoke the same pathetic excuse when they say their craving for children is innate. But can anyone deny that their sexual appetite is perverted? So is the desire for someone of the same sex." End of quote. Children growing up in that environment are subjected to this bile constantly. I would know I was one of them, but at least I survived. Lots don't, like Stephen, the nephew of one of the religion's governing body members. Stephen died by suicide in January 2020, having been disfellowshipped and ostracised for being gay. Yet this organisation is considered a charity in the UK. They hold tax exemptions. They're eligible for direct UK government funding through gift aid. How can that be right? How can an organisation which causes so much harm be charitable? It's not the only example. There are many small religious organisations active in the UK that expose children to horrific teachings, particularly about women and girls. And I highlighted in a Prime Minister's question recently the National Secular Society's Mission and Misogyny report, which is full of such examples. There was one recently, I think quite close to the Minister's constituency. In January, the NSS reported how the Green Lane Masjid and Community Centre in Birmingham streamed a sermon in which listeners were told that discipline in the case of rebellion is one of the rights of the husband over the wife, and further that husbands have a right to obedience as well as a right to intimacy. And I must be clear at this point, as I hope I have been throughout, that these extremist examples happen across faith traditions. This one is Islamic. Equally, I've spent a lot of time up to now talking about a Christian example. And those must not cloud our view of the many religious charities that do brilliant work to support people, but they point to a broken charity system in need of repair. That's why I've been calling for a review into charity law and regulation. We must have ways to make sure that organisations which promote harm towards vulnerable people, particularly through mandated shunning, cannot gain the tax, reputational and funding benefits of a charity. And the Charity Commission needs to seriously step up its game as a regulator. There is a serious pattern of failing to take action despite repeated requests, which the Mission and Misogyny report lays bare. And further, I want to briefly put on record my shock at the recent case where the Charity Commission took legal action against the Parliamentary and Health Service Ombudsman to stop the Ombudsman laying before this House reports detailing complaints upheld against them. My Select Committee had to lay a privilege motion to force the Ombudsman to release the files, which they wanted to, because of the Commission's legal threats blocking them. And I understand they've still pursued that legal action. It's not on. So can I ask the Minister, will she make herself very popular with the Treasury by agreeing with me that organisations promoting hate and abusive practices like shunning shouldn't be eligible for public money, and therefore support my calls for a thorough review of charity status? And will she agree with me that either the Government or the relevant Select Committee should consider a thorough deep dive into the Charity Commission's approach to safeguarding issues? Finally and briefly, I want to touch on a third issue, safeguarding and coercion in medical settings. Again, the witnesses are the clearest example. Many people will know that their religion teaches not to accept blood transfusions. That's described as a personal choice they make. But when the consequence for not taking that choice is shunning and the permanent cutting off of family and friends, is it a choice? Maybe, and religious freedoms of adults to make medical decisions must always be allowed. Similarly, people must always be free to request visits from religious ministers during medical treatment or a hospital stay. But in the witnesses, requests for religious ministers will be met with the arrival of a hospital liaison committee. This is a group of religious elders whose role is simple: enforce the rules on blood transfusions. They will help patients by advocating for their personal choice not to accept blood. They will always claim that decisions are for the patient to make. But the Elders' Handbook, which I believe I have here, somewhere, there it is, the Elders' Handbook clearly states that witnesses should be strongly encouraged to fill out durable powers of attorney for someone else to refuse blood on their behalf. And either way, the Hospital Liaison Committee will be there, watching. And if the patient doesn't comply with the no blood rule, they can expect to be disfellowshipped and shunned promptly. With the HLC there, there's little hope of being able to make a real personal choice in private if it differs from religious teaching, and that really is coercion. Ministers of religion can no doubt provide huge support and relief to patients of all faiths, and will do so. But I would argue that they should not be allowed to advocate for patients' medical wishes where there is a clear conflict of interest, as there are in these cases. And furthermore, these bodies must only be allowed in when the patients request them. A former HLC elder has approached me with allegations that some NHS trusts have established policies to call the HLC by default when a Jehovah's Witness is admitted, no doubt with the best of intentions, as they don't want to do anything wrong. But given they exist to push an agenda which may not be the patient's, that's a serious problem. So I'll close by asking the Minister, will she liaise with DHSC colleagues and push for a review of NHS trust policies toward these bodies to make sure they are only called when a patient requests it, and that patients must have clear opportunities to articulate their final decision in respect of any treatment and receive treatment away from the HLC if they so wish? Thank you.
I call the Minister Jess Phillips.
Thank you, Madam Deputy Speaker. I thank the honourable gentleman, and I am grateful for the important contributions made today, and I welcome the opportunity to talk about the Government's commitment to safeguarding and protecting children and adults from harm across all settings, including within religious and faith communities. I give a special mention to my honourable friend from North West Cambridgeshire for securing this debate and for the compassion and thoroughness he showed and his persistence, I would say, he has shown this House on this issue. Let me first be clear that this Government recognises the central role of faith in our national life. And it is committed to building a Britain where all communities feel safe and where the contributions of people of faith and belief are warmly welcomed and richly valued, as for those, like myself, with no faith. I mean, I've got lots of faith, just not one that would be recognised or organised. The insights of faith and belief groups should and do play an important role in the national conversation around safeguarding children and preventing violence against women and girls. The other central point to make at the outset is that the government utterly condemns all acts of psychological, emotional, physical and sexual abuse against children and adults in all settings, including religious settings of any size or any denomination. All such acts should be thoroughly investigated and the perpetrators brought to justice, as with every case of abuse. My thoughts are first and foremost with the victims and survivors. As this House is aware, we are taking forward an ambitious range of measures to improve safeguarding and child protection through the Violence Against Women and Girls strategy published last year, which deploys the full power of the state to achieve this aim. And through the Children's Wellbeing and Schools Bill, we are strengthening multi-agency safeguarding arrangements and improving information sharing. And we are also taking forward work to safeguard and protect children from harm in out-of-school settings, including religious organisations offering education in their own faith. All out-of-school settings have a legal duty to safeguard and protect children from harm in their care and to support them in meeting this duty. The Department for Education has published guidance setting out the safeguarding standard they should meet, and last year launched a call for evidence to gather views on potential approaches to strengthen safeguarding further, including on potential regulation. The Department for Education is currently analysing the responses and continuing engagement with key stakeholders and will respond in due course. We are also taking action on the recommendations of ICSA, as have been mentioned today, including establishing a Child Protection Authority to improve the national oversight and leadership of the child protection and introducing through the Crime and Policing Bill a mandatory duty to report child sexual abuse. The duty will create a culture of knowledge, confidence and openness amongst those most likely to be alerted to child sexual abuse, and will help children and young people to trust that their voices will be heard when they speak out. The duty will apply to those working or volunteering with children in faith settings, and there will be no exceptions based on religious practices. We will continue to engage with groups that may be impacted to help them manage the implementation of this new duty. My honourable friend raises some specific points about the government's mandatory reporting duty, which I would like to address. We are grateful for the expertise of the child protection sector in shaping the new duty. Our shared aim is a regime that is effective for children and workable for professionals. First, for the avoidance of doubt, the organisations mentioned by my honourable friend have always fully supported the government policy not to apply criminal sanctions to the failure to report. It is true that they also advocate for robust action against deliberate concealment of abuse, but there is a qualitative difference between a lapse in reporting and taking active steps to deter it, or destroying and concealing evidence. Our measures in the Crime and Policing Bill reflect that distinction by creating a criminal offence of obstructing a reporter from carrying out their duty, punishable by up to 7 years in prison. The question of whether failures to report should be subject to sanctions has been fully considered during the bill's parliamentary passage. Most recently, earlier today, during the report stage in the other place, a proposition to amend the bill to this effect was rejected by the House. The question of what triggers the duty, for example, whether to include the observation of signs and indicators, is a separate matter. I recognise that because these issues are often debated in tandem, some conflation may have crept in. The government has not claimed that the stakeholder endorsement for our chosen threshold for the duty, while some stakeholders favour adding recognised indicators or reasonable suspicion that abuse has occurred. As I have set out previously, the government's view is that we need to deliver a model that is clear, proportionate and operable, anchored in direct disclosure, witnessing or recorded material. As with all aspects of the duty, we will keep this under review, but we are confident that the bill as drafted strikes the right balance. I also wanted to respond briefly to the points which have been raised around I often feel anxious that people think that their organisation or any particular example that they can give won't be considered as part of the duty. But most people in positions of any trust, you don't need to name them, are covered by the duty because they work in regulated activity with children, which is the core definition of the bill for a mandated reporter. In other words, if your role as a sports coach already brings you into regular, close contact with children, you'll be in scope.
I thank the Minister for giving way. My constituent is a survivor of abuse within a religious organisation, and she represents a larger group of survivors of the same organisation. She has found the Charity Commission to be utterly ineffectual and far too slow in dealing with her complaint. When I have written to the Minister about this issue, she has referred me to the Ministry for Housing, Communities and Local Government. When I write to the Ministry for Housing, Communities and Local Government, I am referred back to the Home Office. And that same religious organisation continues to operate with the suspicion that there are the same practices that led to the abuse that is claimed by my constituent. Can the Minister advise me that we're a couple of years down the line now with raising these concerns, how I can get some traction on behalf of my constituent to ensure that her allegations and those of other survivors of the organisation are properly dealt with, and this organisation cannot continue to operate with the same practices?
The honourable lady, and I'm more than happy to look directly into the case, but she highlights an important problem that at the moment, the sort of clarity within the system about who is responsible. I mean, first and foremost, if there is child abuse going on in an institution that is raised with anyone, it should be, with the support of the victim, reported to the police. I understand, I don't know the details of this case, but absolutely I will come on to the specific issues that were raised specifically about the Charity Commission. But as has been highlighted during this debate, I am not, without being a constituency MP who has had to raise these issues myself, with the Charity Commission, and we have to make sure that the regime of regulation within our charitable sector is as robust as it can possibly be on safeguarding, as well as financial irregularity and other things. So I don't disagree with what she has said. I will give way, yeah.
Way, I just want to explore with her, if I may, a little bit about what happens, because there is a mistrust of external agencies in a lot of these small, high-demand religious organisations, by which I think I would probably mean those that look very like cults, where people may not realise that they have any capacity or agency to actually report.
I mean, with the mandatory reporting duty, there will be a huge body of work that goes into guidance about how and how you should report. And those, however small, however nervous, they are covered by the duty. To the issue, and I only have 3 minutes still to speak, to the issue specifically of faith-based charities and promoting misogyny, I absolutely hear the concerns that have been raised. The Charity Commission has apparently reviewed the National Secular Society report on religious charities promoting misogyny and has confirmed that it has already assessed and responded to a number of incidents. I will follow up on that action, and I will gladly meet with the honourable gentleman once I have a fully robust answer as to why we think that it is acceptable for any charity in our country. He invites me to, I suppose, annoy, I don't think he used those words, but annoy the Treasury. But I absolutely agree with him that the idea that you could promote that, for example, like the examples that he gave, the hatred of women or the supplication of people's wives, and be considered charity seems alien to me, and I will absolutely follow up on that. Furthermore, as the Prime Minister announced recently, the government is already working on with the Commission on plans to give it additional powers to help tackle extremist abuse, and that would be barring anyone convicted of hate crimes from serving as a trustee and making it, easier for the Commission to act against anyone undertaking that, and these changes will be made after a public consultation coming this month, which I invite everybody to take part in. I absolutely will speak to DHSC on the issue of medical coercion. It is not something that I am that I lead on as a minister, but I don't disagree with him that people have to be able to make those decisions in full and frank view. So in closing, I just want to thank my honourable friends, and I promise that we will continue to try and work together because we all actually want the same thing.
The question is that this House do now adjourn. As many of that opinion say aye? The ayes have it. The ayes have it. Order, order.